Today we're going to talk about the unwritten principles of the Canadian Constitution, with the intent of helping both you and I with our constitutional law exam prep. We will reference general notions of these principles: parliamentary sovereignty, rule of law, democracy, judiciary independence, protection of minorities, constitutionalism, public service neutrality, no taxation without representation, separation of powers / federalism, solicitor-client privilege, parliamentary privilege, and the full faith and credit doctrine. General rules for the unwritten principles. Fill in the gaps, but do not override the written text. From the reference remuneration judges, provincial courts, Prince Edward Island case. Symbiosis, not in isolation. No principle trumps or excludes the other. Secession of Quebec. From the same case, substantive limitations on government action, and these limitations are binding. Unwritten principles must be balanced with parliamentary sovereignty. Babcock case. Unwritten laws could not override properly enacted statutes. Imperial tobacco case. Unwritten principles can be used to quash administrative decisions. Ron Corelli case. Democracy and constitutionalism very strongly favor the upholding of the validity of legislation that conforms to the expectations of the Constitution. Imperial tobacco. Parliamentary sovereignty. The right to make or unmake any law. No override by any person or body. Hodge v. Queen case. Legislator enacts any law that does not fundamentally alter or interfere with the relationship between courts and other branches of government. Babcock case. Next unwritten principle, the rule of law. Subjection to known legal rules and executive accountability to legal authority. Resolution to amend the Constitution. Stable, predictable, orderly society. A shield for individuals against arbitrary action. Reference Secession of Quebec case. Exercise of all public powers must find their source in legal rule. Provincial judges reference case. Allows courts of law to overrule arbitrary administrative actions. Baker case. Governments will act reasonably in good faith, relying on relevant grounds without discrimination, errors, or lack of evidence. Maple Lodge Farms case. Access to justice is essential to the rule of law. Trial Lawyers Association case. Next principle, democracy. From the resolution to amend the Constitution and the Ontario v. OPSEU case. Allow for public participation through public institutions created under the Constitution. See also reference Secession of Quebec. Powers of government must be exercised according to public opinion. Protection from legislation some view as unjust or unfair lies not in underlying principles of the Constitution, but in its text and through the ballot box. Imperial tobacco case. Use of unwritten principles as a tool for statutory interpretation is consistent with the use of charter values when interpreting statutes. Bell Express View v. Rex case. Next principle, judiciary independence, from the Beauregard case. Judiciary independence is inferred from the Constitution Act of 1867 preamble, also sections 96 to 100 of the Constitution Act of 1867, also section 7 of the Charter. Judiciary independence represents procedural fairness. Reference remuneration of judges, provincial courts, Prince Edward Island case. Absence of bias, actual or perceived, RV Valente case. Same case, individual and institutional independence. Impartial arbiter to settle jurisdictional disputes between federal and provincial orders of government, provincial judges reference case. Equally applies to intrusions from the legislative branch. Guarantee of security of tenure, financial security, and administrative independence. Reference remuneration of judges, provincial courts, Prince Edward Islands case. Next principle, protection of minorities. Where interests of minorities have been denied consideration, especially when the group has historically been the target of prejudice and discrimination, judicial intervention is warranted. Vrend case. Next principle, constitutionalism. All government action must comply with the Constitution. Any known inconsistency with the provisions of the Constitution is, to the extent of the inconsistency, is of no force or effect. Reference secession of Quebec case. Same case, interest of all groups must be considered and accommodated prior to changes being enacted. Next principle, public service neutrality. This is considered a fundamental pillar from the OPSEU case. Historical practice has resulted in public confidence in the civil service, and this confidence requires neutrality and impartial service regardless of the party in power. Also from the OPSEU case. Powerful reason for the requirement of loyalty, neutrality, fairness, and integrity of public employees, and that reason is a public interest in both actual and apparent impartiality of the public service, from the Fraser versus PSSRB case. Next principle, no taxation without representation. This is determined to be constitutional from the Ontario English Catholic Teachers Association case. Bills for appropriating any part of the public revenue or for imposing any tax or impost shall originate in the House of Commons, Section 53 of the Constitution Act, 1867. Parliamentary control over and accountability for taxation. Urig estate case. Next principle, separation of powers / federalism. Fundamental principle confirmed by distributing legislative powers in Section 91 and Section 92 of the Constitutional Act of 1867. Also referenced in the Reference Securities Act case. Each level of government should not be permitted to encroach on the other, either directly or indirectly. Resolution to amend the Constitution. Federalism, limited principle of parliamentary sovereignty to each head of power as distributed by the Constitution. OPSEU case. The court favored accommodating cooperative intergovernmental efforts to challenge complex issues that cannot be specifically allocated to any specific head of power. Reference Re Securities Act case. Next principle, solicitor-client privilege. This is a principle of fundamental justice from the Lavallee, Rector, and Hans case. Communications to the solicitor kept secret unless with their consent and necessary to properly conduct litigation from the Anderson versus Bank of BC case. If the client seeks guidance in order to facilitate commission of a crime or fraud, the communication will not be privileged. Solosky case. The solicitor-client privilege does not apply if it prevents the accused from bringing forward relevant evidence or to make full answer in defense to criminal charges. See Boyer case. Next principle, parliamentary privilege. Necessary immunity that law provides for members of parliament, members of provincial legislature to do their legislative work. Also for anyone well taking part in a proceeding in the parliament or legislature. The authority/power of each house of parliament to enforce that immunity. From the Parliamentary Privileges in Canada case. Privilege held absolutely and constitutionally if they were to be effective. Crown and courts could not touch. New Brunswick Broadcasting versus Nova Scotia case. One exception, Parliament cannot, under Section 18 of the Constitutional Act of 1867, grant privileges, immunities, and powers that exceed the powers held by the House of Commons in the United Kingdom in 1867. Nevertheless, powers must be allowed to adopt to the changing circumstances that exist today, the Vade case. These privileges are part of fundamental law of land and hence are constitutional. New Brunswick Broadcasting v. Nova Scotia case. The final principle that we will discuss today is the full faith and credit doctrine. The recognition and enforcement of judgments in any province of Canada, regardless of province where the judgment was rendered. It was the obvious intention of the court to create a single country. Morgard v. de Savoy case. All judgments are subject to the final review of the Supreme Court. Parliament had power to legislate respecting recognition and enforcement of judgment throughout Canada because it's related to the rights of the citizen, trade and commerce, and other federal legislative powers, including POG. Other written principles were incorporated into the Charter, so they will not be discussed today, such as freedom of religion, speech, press, etc. Click like, click subscribe, check out these other videos on constitutional law, and eventually even more Canadian law and NCA exam prep down here in the corner. And best of luck to you on your upcoming exams.